This is the ever-popular legal update slot, and this year we're lucky to be guided through the maze of notable cases by Saira, Kabir, Sheikh of Francis Taylor Building. Saira has been involved in a wide range of high-profile planning and infrastructure projects. She was called to the bar in 2000 and took silk last year, a truly meteoric rise. She's the youngest ever silk in her chambers. Saira, hello.
Hello, Claire.
It's been a busy year in the courts, as usual. We've had a lot of decisions this year about housing development, not surprisingly. Are there any that stand out in particular?
Claire, you're quite right. There have been a real range of decisions relating to the supply of housing and policies relevant to the supply of housing. The three that stand out are Hopkins Homes, Cheshire East, and finally Fidey's Estates. They all take an approach to the policies and whether or not they are relevant to the supply of housing. If I had to pick from these three, I would put my money on Fidey's Estates, which takes an approach that doesn't seek to actually substitute the judgment of the inspector as to whether a policy is a relevant policy for the supply of housing, but says as long as the inspector has understood the relevant paragraph in paragraph 49 of the framework, it is a matter for his or her judgment whether or not it is a housing supply policy. That is the most recent decision. The other two are in fact on appeal, so it'll be interesting to see which approach in fact prevails.
Out of all the decisions, and I know they cover a wide range of different topics this year, if you had to pick one decision you would say was the most important, the most significant, what would it be and why?
Claire, it is very difficult. There are some very interesting cases this year, but in terms of significance, I think I'd have to go for Champion and Norfolk District Council. In the Champion case, there was a question about the approach to the Habitats Directive and the environmental impact regulations. But the two important points that emerged in that judgment, quite apart from the substantive issues, relate to the question of discretion in environmental cases, which formally have been considered not to be susceptible to the application of discretion where there's been a breach of the directive. And the second point relates to delay in bringing challenges to screening opinions. In this case, Lord Carnworth and the court, the Supreme Court, found there to be a breach of the European directive, but nonetheless found that it was an appropriate case to exercise their discretion, not to quash. So that puts on a Supreme Court footing the approach taken in Jones and Mansfield in the Court of Appeal. In terms of delay, there seems to be a rowing back to some extent of Burkitt, which talked about a challenge being at the end when permission was granted, but in this case, Lord Carnworth is not ruling out that delay may feature as a basis for discretion if a challenge is not made to the screening opinion in a timely manner.
So good news for developers, really.
Definitely good news for developers. The words from Lord Carnworth are quite strong to developers as well, saying you need to get it right and you need to not just go with the flow. If you think there should be an ES, you need to do one. But having said that, there is not going to be a technical approach to breaches of the environmental directive. Unless there is some substantive prejudice, it's likely that the courts will now look at the application of discretion and not quashing.
So would you say that this is a trend, the courts willing to intervene to salvage decisions? Would you say we're seeing more decisions of that nature this year?
Well, I wouldn't like to say that the courts are salvaging bad decisions, but they are certainly looking at the new procedural test as well, which is that if it is highly likely that the decision would be the same, even if the error had not occurred. So even if it were quashed, you're going to end up with the same decision. If it's highly likely rather than inevitable, the new legislation says that you should exercise your discretion not to quash. So yes, perhaps a trend just before the legislation came in, hopefully not salvaging substantively bad decisions, but perhaps taking a more pragmatic approach to decisions that are highly likely to be the same.
Throughout the conference, a theme has been the problems caused by lack of regional strategies, problems with duty to cooperate, What's your view on this based on the case law this year?
Yes, well, as I discussed in my paper and at the talk as well, the problem with the duty to cooperate is that there is no real stick to require an outcome. So although the PPG talks about successful cooperation being measured in outcomes, it is, in my view anyway, quite unrealistic where you have entrenched positions and political agendas, obviously. It is ultimately got a political context to it. It's quite unrealistic unless there is some top-down approach really to ensure and get those outcomes. A lot of the problems arise because plans are at different stages, and therefore you can't have the coordinated approach that is sought by the duty to cooperate. So good idea, aspirational, unlikely, I think, to achieve or be a substitute for regional planning.
Great, that's really helpful. Thank you very much, Saira.
Thank you very much.